behalf of all of us at Jenkins Fenstermaker, thank you for coming today. We got some tremendous speakers, Gary Matthews, Sarah Walling, Stephen Snyder, and Mike Fry, in no particular order. Notice I didn't include myself on that list of great speakers, and I think you'll see why in a few minutes. Actually, I'm just kidding. We do want to thank you for being here. And what we've seen over the last few months, 6 months, maybe even going back even further to 2016 and the election, are headlines and conversations about sexual harassment and how it's sometimes conflated with sexual assault and whether sexual harassment is sexual assault. And it's led to a larger cultural conversation about gender roles and about the workplace and about how people treat each other. And I think particularly over the last few months, we've seen an uptick in conversations with clients about this particular issue. And we do these seminars from time to time on different issues. I think this is the first one we've done strictly on sexual harassment. But we thought it was important, an important conversation to have with clients and with the community. So thank you all for coming. Before I get started, one thing I did want to address right at the topic, and I don't use social media, so I wasn't aware of this until yesterday morning, but I understand that there was some conversation about the title of our program. He said, she sued. I just want to address that and say, when it was brought to my attention, I looked at it and said, that's probably not the best title with considering the sensitivity of the topic and the implication, or the many implications that could come from this. We didn't mean to imply that women are running off to the courthouse at the slightest provocation to file sexual harassment suits. So if anybody took offense to that, I apologize. It wasn't the intent. And I think you'll see from the conversation today that there's really a broader conversation that we're having as a society, and this is probably just an innocent slip-up that all of us are having, or many of us are having, especially men. So with that said, and with my sincerest apology, I'll go ahead and get started. I just want to give a quick overview of what sexual harassment is, what the law says it is. And as we're going through this, take a look or think about the way that this is treated objectively, both in terms of what a lawsuit could be, or what the objective conduct is, and the subjective, how conduct could be taken, how one person might take it differently than somebody else. And alluding to that other cultural conversation that we're having, ask yourself, do traditional notions of what is objectionable still matter? Or maybe a better way to put it, have our views changed, or are they currently changing? So let's just jump right in, what the law says. And I understand there's a complete federal counterpart to this also. I've just kind of taken what's in the West Virginia Code, or in the state regs. Sexual harassment claims come from the Human Rights Act. The Human Rights Act provides that employees have the right to work in an environment free from discriminatory, intimidation, ridicule, or insult. And if harassment on the basis of sex occurs at the workplace, it's a violation of the Human Rights Act, just like discrimination on the basis of gender, on the basis of race, on the basis of disability, on the basis of religion. So, what is sexual harassment? What are the hallmarks of it? What does the code say? Sexual harassment consists of unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. We don't have to talk about the other conduct of Louis C.K. It's just suffice to say that it was conduct of a sexual nature. The first aspect of sexual harassment, well, let me back up a second. These three things, unwelcome advances, requests for favors, or other conduct, strictly speaking, are not in and of themselves sexual harassment. That's not to say I encourage anybody to do these things in the workplace, but there has to be something more than that. In the first part, there could be a quid pro quo. Everybody knows what that means. I do something for you, you do something for me in return. If sexual harassment, if these unwelcome advances, requests for sexual favors, are premised on, if you do this for me, I'll do something for you, or if job decisions are made based on those advances or the request for sexual favors, that's quid pro quo sexual harassment. In other words, if you come to my hotel room, I'm only wearing a bathrobe, and you give me a massage, I'll promote the hell out of your movie, and we'll make a lot of money. Or if you come to my hotel room, and I'm only wearing my bathrobe, and you watch me take a shower, I'll give you a role in a big movie. Holding a carrot out there and saying, if you do this for me, I'll do something for you. That's one way to prove a sexual harassment claim. But keep in mind what the code says, explicitly or implicitly a term or condition of employment. So it's not always a meeting of the minds. And I think about Matt Lauer and Charlie Rose. They're two well-respected journalists who had great careers. They were well-liked. And you have to wonder, they both carried on affairs with multiple spouses throughout their careers. So you have to wonder, did some of these people that they carried on relationships with think to themselves, implicitly, this could help me in my career if I do this? And that was why they engaged in that relationship. Or this could be bad for me if I don't engage in this. So they went ahead and did, without any overt offer, or without any overt penalty from these gentlemen. The other way, aside from quid pro quo, this quick is a little sensitive, I'm sorry, is whether a hostile work environment exists. Just by way of example, everybody remembers Justice Thomas, nominated to the Supreme Court by George Bush, 41. During his confirmation hearing, Anita Hill was called to testify, and she testified about a number of acts that Justice Thomas is alleged to have undertaken. While they worked together, he asked her out many times, which in and of itself is probably maybe an unwelcome advance, probably pretty innocuous. He discussed sexual subjects. He discussed pornography involving gang rape, rape and group sex, is that what it is? Yeah. And he graphically described his own prowess and his own anatomy. So you have to ask yourself, if these are unwelcome, is it creating a hostile work environment? You all heard this phrase before. Mr. Bissett talked about this at the top. Is this creating an atmosphere where it's interfering with somebody's ability to work? Is this creating an atmosphere where somebody doesn't want to go to work? And the way I think about a hostile work environment, I think about being 12 years old and having a couple kids pick on me and not wanting to go to school. Getting up in the morning and telling my mom I was sick, even though I wasn't. And you go to school and you just kind of hang your head and just hate being there, until it's over. That to me, and I don't mean to trivialize what a hostile work environment is, but it's that feeling that this is just too much. I can't handle this, and it's because of some outside force. Other examples of hostile work environment, Fox News edition. And not to pick on Fox News, but Roger Ailes had multiple allegations made by many women. Gretchen Carlson, he talked about them having a sexual relationship, amongst other things. Andrea Tanteros, he made comments about her body, requested physical touching. Kelly Boyle, he made the comment to her, if you want to play with the big boys, you have to lay with the big boys. And Rudy Bacchar, he asked her to stand during an interview so he could see her legs, and he must have liked what he saw because he thereafter started sending her miniskirts to wear to work. This is not typical behavior, and this is behavior that's designed to do something, even if it makes them uncomfortable. I think these are the hallmarks of somebody creating a hostile work environment. So we've done the brief overview. Sexual harassment consists of unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature. And we talked about it could be quid pro quo. You do this for me, I'll do something for you. Or it could be actionable by way of a hostile work environment. But is it yet a claim for sexual harassment? And the answer is no, not quite yet. The harassment needs to be severe or pervasive. And we have a list of factors that we can use to assess whether the conduct is in fact severe and pervasive. Was there physical touching involved? Was there verbal abuse of an offensive or threatening nature? Were there unwelcome and consistent sexual innuendo or physical contact? And what was the frequency of the unwelcome or offensive contact? Before we're going to say that the unwelcome advances, etc., constitute sexual harassment, we're going to test whether it's in fact severe and pervasive. So, what if it's a one-time thing, an isolated incident of harassment? It probably fails that test of whether it's severe and pervasive. Makes sense. However, a person who has been harassed on an isolated basis can point to evidence of other people being harassed as evidence that harassment in the workplace is severe and pervasive. So even if I harass Mike Fry one time, he might go back and talk about how many times I harassed Gary Matthews at the office to demonstrate that there is this culture and that the harassment in my office or in our office is severe and pervasive. Case in point, if you go back to the Fox News example, all the conduct I talked about before was that of Roger Ailes and 4 other women. This case involves Bill O'Reilly and Liz Wheel. These are the allegations she made against Bill O'Reilly. But let's assume that they were isolated. Let's assume it was just, a 1 or 2 time thing. She can still point to the conduct of Roger Ailes with regard to the other women to show that the harassment in their workplace was severe and pervasive, even though she may have only been harassed on an isolated basis. So let's talk about the liability part. If we've kind of checked all those boxes and we get to the part where there's unwelcome advances, requests for sexual favors, it's quid pro quo, or there's a hostile work environment, and it's severe and pervasive, what is an employer liable for? If you're an officer, an agent, or a supervisory employee, the employer stuck with your conduct. They're liable, whether the conduct was forbidden or otherwise authorized. For fellow employees, somebody who may not have supervisory authority over another, may not have control over the other, the employer may still be liable if they knew or should have known of the conduct and explicitly or implicitly authorized or ratified the conduct. A defense to this, though, is if the employer took timely and appropriate corrective action. You're going to hear more about this from the other folks later. But you're not out of luck just because you knew or should have known or explicitly or implicitly authorized it. If you took timely and corrective action, you can use that as a defense to a claim. What about employees who come onto your premises? An employer can still be responsible for them if the employer, again, knew or should have known of the conduct and failed to take timely and corrective action. A non-employee, if you have a vendor, you have salespeople that come in, repeat customers maybe, who knows? Non-employees that you don't have any control over in an employer-employer relationship could hang you with liability. So what are the ramifications, practically speaking? We're a bunch of lawyers here talking to you, so we want to talk to you about lawsuits. And we want to talk to you about the attorney's fees that you're going to incur. We know none of you like to pay us, but nonetheless, we're still going to charge the fees. So if you have an instance of sexual harassment and there is a lawsuit, there are very practical ramifications in terms of you've got to find a lawyer to defend you. You may have insurance for that, which is great, good for you. I've defended as many employers in employment cases who don't have insurance and who have paid us out of pocket instead of having an insurance policy where the insurance company will pay for it. If you're in litigation, make no mistake that there is a huge disruption in your business. We try to be sensitive to that, and we know that we disrupt your business when we have to defend a lawsuit, but it can be time consuming if we're asking you for documents. We say, all right, we need to talk to employees A, B, and C. And after we talk to employees A, B, and C, we say, now we need to talk to employees D, E, and F. Then after we do that, we do some more discovery. The plaintiff's attorney comes back and says, we want to depose employee G. And we say, what in the world does employee G know? That hasn't come up before. Now we need to talk to employee G. And eventually we need to schedule all those people for deposition preparation, so we need to take them out of work for half a day. Then we need to actually take their deposition, or the other side needs to take their deposition. These are huge disruptions to your business, things that you don't want. So in terms of prevention, again, you're going to hear more about that from these folks later on. And certainly the exposure of a claim. If you want to settle a sexual harassment claim, we're going to have to put a value on it, and we're going to try to negotiate it, and that's going to be money spent. If you don't want to settle it, or if the other side doesn't want to settle it, there are damages involved. If you lose, you're looking at lost wages, if the person's no longer employed, emotional distress, and certainly depending on the severity of the conduct at issue, an emotional distress award could be substantial. Punitive damages, maybe. It's an employment case here, it's fee shifting. If the other side wins, you have to pay their attorney's fees. The downside of sexual harassment cases and employment cases is potentially catastrophic to some employers, which is why the prevention part is so important. Somebody who's not the victim, the direct victim of sexual harassment, could still have a claim against you. Say you have an employee who took the bargain on the quid pro quo, and they got the benefit. You have another employee who is equally qualified for those opportunities or benefits, and they didn't get it because the other person who took the quid pro quo did. That other person, but not the direct victim of sexual harassment, may have a lawsuit against you for that. And finally, employee morale. If you're fostering a hostile work environment, or you have people who are receiving preferential treatment because of sexual activity in the office or sexual relationships or sexual harassment, employee morale, I think, as a general rule, is bound to suffer. So what I'll leave you with briefly, and I'm not too terribly over my time. Actually, I don't think I'm over my time quite yet. At the beginning, I said, throughout this program, ask yourself, do traditional notions of sexual harassment or how we treat these claims or how we view these claims still apply? I think, yeah, of course they apply. They're always going to apply. But have our views changed, and are they changing? And I think when you see what's happening in our culture, and although it may not be downtown in Huntington, it's certainly all around. It's in the news. You can't go through the last 8 months of any issue of any magazine and not find a reference to Me Too or the Women's March. These issues are becoming more and more important, more and more visible. There are stronger and louder and more collective voices on the women's front. And I think that's certainly a good thing. But I think as a culture and as a society, we have to recognize that we are in the midst of some type of change, and we don't know what it is. So what I'll also leave you with, and if you consider this as a spectrum, where on the one side you have President Trump, whose position with regard to the allegations made against him, they're all lying. And Sarah Huckabee Sanders said it recently, that his position is all those women are making this up, and the American people don't care because they knew about it and they elected him anyway. So take that as one extreme of this spectrum. Then if you look, step a little bit closer to the middle, you have Matt Damon, who was lambasted on social media for taking the position that there's a spectrum of behavior in terms of sexual misconduct. Now, again, I'm just a dumb guy, so I think that's a pretty reasonable position. Rape is different than sexual harassment, which is different than. And I can see what he's saying. But again, that's kind of a typical guy's approach to this, right? I think we have to recognize that that's changing, and it's evolving into something more like, we shouldn't be saying boys will be boys, we should be saying boys should be good people. They should be good humans. And then on the other side of that, you have Me Too and Time's Up, and the real voices who are advocating for real change, and have been for the last 15 months or so in a very public way. And I make this point, and again, I wanted you to think about the subjective elements of all this as we go through today. I think wherever you find yourself on this spectrum, you have to recognize that there are broad views on this. And if you have a sexual harassment claim and you put a jury of 6 people in the box, you can have all 4 of these claims represented. If you have a place of employment with 10 people, 20 people, 50 people, you're going to have these different perspectives. And if you're talking about something like sexual harassment, where inherently it's going to be based on what one person says to another or what one person does and how another perceives it, you're going to have to understand that people are going to perceive things differently, that they're going to understand things differently. And the conversation that is being had may not be understood when someone who's on one far side of the spectrum is communicating with someone on the other far side. So I think we have to recognize what's going on culturally and that things are changing. And whether you agree with it or not, recognize that these viewpoints exist in this room. In this room, all these 4 viewpoints are representing a positive of. So one last thing I want to talk about, the subjective, and just one more brief anecdote from the news recently. Has anybody not heard of the Aziz Ansari story? Okay. So I won't go into the great detail about it, but Aziz Ansari is a comic. He's fairly famous. He's kind of a rising star. I think he's moderately funny. Other people think he's funnier than that. But recently, I guess he had a sexual encounter with a woman. And by both accounts, it was consensual. She doesn't dispute that. She's not saying that he raped her or that there was actual sexual assault. But the next day, or sometime after, she felt differently about how the whole series of events unfolded. And she wrote an article, and she more or less called him out for not being able to pick up on her nonverbal cues, not being able to kind of sense that this isn't going the way she wanted to go. And because she felt differently about it, she thought she needed to speak up. And although she consented to the encounter, and she never really withdrew her consent, it's caused quite a bit of a stir. And there are voices on both sides of that spectrum weighing in with their own opinions about, on the one side, hey, she consented, what's she complaining about? And then on the other side, they're saying, this is kind of muddy ground here, and this is very deeply personal, and she may, after the fact, feel very violated. And we should be sensitive to that. It doesn't matter where you fall on that. But I want to use that just to highlight the subjective elements of this, and that the effects of time can really have a change, or it can really have an impact on how people view conduct, whether it's comments made, physical action by anybody. In the Aziz Ansari incident, just a short period of time made her rethink the way she felt about it. And she rethought it in a very profound way. And to take the example that you could have somebody who experiences some type of conduct today, whether it's a sexual advance by a coworker or a supervisor, and maybe they're okay with it, maybe they're all about it, maybe something good happens from it. Now you go 6 months down the road, and something totally unrelated has happened, but they've soured on their job. Maybe they're not doing a good job, maybe they just don't like it anymore, maybe they're having personality conflicts, they're disengaged, they're looking for a way out of this trouble. 6 months after the fact, they look back at that initial encounter, and they can look at it and say, I feel differently about that now. I may have been all about it at the time, but now it's got a different shade to it. I kind of changed my mind about what that conduct was, so even though I was okay with it at the time, maybe later on it turns into something else, and it becomes the basis for a claim for sexual harassment. So I think we have to be cognizant that time and subjectivity can really influence the way these things play out. And certainly the last point I'll make, time certainly can give some people the courage to speak up and speak out when they may not otherwise have done so. So again, my job is to give the broad overview, things to think about. So keep these things in mind as you listen to the rest of these speakers today. They have some very insightful things to share with you. I always learn something when we do these things. So thank you. I'll be around here afterward if anybody has any questions. Like I said, I'll take the easy questions, save the hard questions for these four. And thank you all again.
You heard Nate give an overview about sexual harassment. I'm going to be talking about risk factors for harassment. And then after that, we're going to hear about policies, we're going to hear about training, and then we're going to hear about investigation and enforcement. So we're trying to give you all an overview, basically from beginning to end, of how you, the employer, can deal with sexual harassment. What I want to talk about, as I said, are risk factors. I want to talk about what you can do in order to prevent harassment from ever occurring. And when we talk about sexual harassment, we talk about the risk factors. Well, what is the risk we're talking about? According to a recent survey, more than half of all American women have experienced what would be considered as sexual harassment. And 30% of women have endured sexual harassment from their male colleagues at work. 25% say those male colleagues who were harassing them happened to be ones in positions to influence their careers. Their bosses, people who can contribute to their evaluations, people that had an effect on their career. So this is not a small problem. However, it is a problem that can be hidden, just like an iceberg. 72% of women, according to one survey, a recent survey, who experienced sexual harassment did not report it to anyone. They kept it quiet. That's a huge percentage. That's an enormous amount of people being harassed who aren't reporting it. 54% of women who were harassed did not confront the harasser. They just suffered silently. Okay, let me go on to the next point. Why didn't they confront the harasser? It's because, according to this same survey, 13% of those who did confront the harasser said that the situation stayed the same. 9% said it became worse. So it's a serious problem we have in our workplace. So how do we combat this risk? Well, training alone isn't going to work. This is a quote from an EEOC commissioner, Victoria Lipnick, where she says, if you are thinking training alone is a panacea to helping out any type of harassment, it's not. It doesn't work. It alone does not work. So what is going to work? What might work? One, you need a committed leadership. You need a leadership at your work who says, we are going to make this a safe workplace for everyone. That commitment comes through in the form of good policies and procedures, ones that are understandable, and also ones that the employees are trained upon. Having good policies alone means nothing. I've had lawsuits where the defense of my clients was, well, we had this great policy. And then the next question was, well, did you distribute it? Well, yeah. We did that the very first day during employee orientation. Did you ever do it again? No. Did you ever sit down on a periodic basis and explain it? No. So a policy alone is almost worthless. You have to have training. And Gary's going to be speaking about how to do better training. And then investigation and enforcement. You have to investigate complaints, and you have to be consistent about your enforcement. Sarah Walling will be speaking about that. And again, let's go to the risk factors. How do we help prevent harassment from occurring? The EEOC had a select task force a couple years ago that put out what I thought was a very informative report. It's just basically called the report of the co-chair, Chai Feldblum and Victoria Lipnick, these two women, Ms. Feldblum at the top, Ms. Lipnick at the bottom. And this task force report is available on the internet. It's free from the EEOC, download it. I thought it had some excellent ideas. One is, let's look at the risk factors so we can try to figure out how we can ameliorate them, how we can address them proactively. One risk factor the task force established was homogeneous workforces. Workforces that are basically one sex or maybe one race, anywhere where there's a majority that's in conformance, that has the same characteristics. That's a workforce where you're likely to have some harassment. And I would submit that it's not just sexual harassment. I would submit that that would give grounds to many types of discrimination, religious, racial, ethnic, etc. When you have a homogeneous, non-diverse workforce, that is a risk factor. What are some of the mitigation steps you might take? Well, a commitment to diversity. This is again from the EEOC task force saying that a leadership that's committed to a diverse, inclusive, and respectful workplace, that's key to preventing harassment. Another set of commentators said, well, it's pretty simple. When you're talking about sexual harassment, hire more women, right? If you have women leaders, women in positions of power, it's less likely you're going to have a workplace that's tolerating sexual harassment against women. Another risk factor that the EEOC task force identified was a workplace where some workers don't conform to workplace norms. So for instance, well, I had one manufacturer, almost an all-male workforce, a couple of women in the workforce. They were outliers, right? They didn't conform to the norms. And they were at a greater risk of being harassed because they were isolated, basically, among the workforce. It's a risk factor. So if you have a workforce like that, or you have a workforce where some people, let's say you have a man who dresses very feminine, or a woman who dresses very masculine, and they're outliers, they are exceptions, that's a potential risk factor. So one mitigation is be proactive. Don't wait for complaints to arise. And why not? Well, we already saw most complaints aren't made, right? Most actions that could give rise to a complaint do not result in a complaint. So be proactive. Don't wait for the complaint to arise. Ensure the workers understand their rights, again, training, ongoing training, and ensure workers understand their obligations. One thing you should think about in your workforce is, have you trained your workers that they have an obligation to report harassment if they see it? Do you tell your supervisors and coworkers, if they see someone being picked on and harassed, they have an obligation to come forward? And if they don't come forward, they themselves may be the subject of discipline. So that's one possible way of mitigating this risk. Another risk factor the task force identified is cultural and language differences in the workplace. And they were talking about what happens when you have a large group of people that are somehow different from the existing workforce coming in. So for instance, after the Vietnam War, a lot of Vietnamese immigrants came in. That's a new factor in the workplace. It's a new group of people. This is a picture, an old picture of the Irish coming to America, and that's an awful lot of prejudice. So when you have new groups coming into the workforce, that's a risk factor. So, mitigation ideas. One, you want to speak the language. You want to be sure that the workers have someone who, if they speak a different language, they have someone in management they can talk to. Ensure the workers can speak to management, vice versa. You be aware of the change in demographics. And you want to stress your company's anti-retaliation policy. There are a lot of countries that don't have the same commitment to a rule of law as we do. A lot of countries where people are afraid to report problems because they've experienced retaliation or worse. And so you need to stress anti-retaliation to all your workers to ensure a more conducive atmosphere for complaints being brought forward. Another risk force the task force identified was coarsened social discourse outside the workplace. I think until now I've never said that out loud. Coarsened social discourse. So what's that mean? What are we talking about here? When times get ugly in the outside world, you can expect it to filter into your workplace. So for instance, and I'm just speaking, hypothetically here, if you have, let's say, a national leader who says everyone from Mexico is a rapist, you might be worried about the Mexican workers you have in your workforce. That coarsened atmosphere outside may very well filter in, and the people in your plant, in your employment, who are Mexicans, they may be feeling effects from that attitude. Or the same thing with Haiti. If you say everyone in Haiti, well, I'm not going to repeat the language, but if you denigrate in the outside, if there's denigration and prejudice and hatred outside your walls, don't be surprised if it comes inside too. So it's a risk factor. How do you mitigate that? One, let's pay attention, right? Pay attention, and this is, again, not just for sexual harassment, it's for any sort of discrimination. Pay attention to social trends. Pay attention to what's being said. Pay attention to events outside your walls. And also, as part of any compliance program, you want to pay attention to new legislation, new court cases, and adapt. Another risk force, workforces with many young workers. Why is that a risk factor? Okay, one reason is young workers may be very well intentioned, but they may be more used to the atmosphere in college or in high school, and they may goof around and they may not understand that some of the horseplay and some other behavior is inappropriate and unprofessional. They don't know the social norms yet at your workplace. And so, mitigating ideas. One, you might want to partner young employees with more experienced employees who are not their supervisor. And why is that important? Why is it important that they not be the supervisor? Well, a good mentor is someone to whom the employee can speak freely without fear of having it be reflected in their evaluation or fear of having discipline taken against them. So a mentoring program with people outside the reporting chain can be very helpful. Also, you want to stress civility and professionalism, and not just avoiding legal liability. And Gary will get into this more when he talks about training. But this is something I don't think I really appreciated until quite recently. Because as an attorney, I always talk about legal liability. Here's what you need to do to avoid being sued, or here's the trigger point at which it goes from being offensive to being to establishing legal liability. But what the EEOC task force is saying, and I think it's very smart, is that you really need a buffer zone. Before you get to the point where it's legal liability, you want to have a buffer zone where you talk about civility and professionalism. You want a workplace that is professional, where there isn't the horseplay, there's not the practical jokes and the hijinks. And if you do that, it's less likely that behavior is going to develop into actionable behavior that you can be sued for. Risk factor. Employees with workplaces rather with high-value employees. So every workplace has some employees who are going to be considered important, right? At a law firm, for instance, we have employees or lawyers who have very big books of business, our rainmakers. They're very high-value employees. At Miramax, they had Harvey Weinstein, who was an incredibly important player. And the EEOC task force says that when you have these very high-value employees, that is a risk factor you should be careful about because they may feel they're above the law. They can get away with anything. They know they're important, and they've probably been coddled a bit in breaking certain rules along the way, not just sexual harassment, but other rules too. They probably get more license because they're very valuable. That's a risk factor. To mitigate that risk factor of the high-value employee, you need to make sure that your discipline is prompt, it's proportionate, and it's consistent. You don't let anyone get away with violating the rules. Supervisors also need to be held accountable for harassment in their departments. Again, bystander intervention, everyone's responsible for having a professional civil workplace. Now you might say, well, yeah, how do you really do that in real life though, right? With Harvey Weinstein, how do you do that when he's such an important figure? You got to take action. Look what's happened to Miramax now. It's basically been destroyed because of his behavior. So it can be painful to confront the high-value employee, but I would submit it can be much more painful to let it go unchecked. Another risk factor, and this is similar to what I just talked about, the EEOC has said workplaces with significant power disparities. So you might think, again, I've worked in a law firm for 25 years now, you can see sometimes that the lawyers or the partners have a different power than the staff. And in situations like that, or in a factory, right, the foreman or the white-collar workers, and then you have the blue-collar workers, or retail operations, store managers and employees. There's always going to be some power disparities. And the EEOC is saying where those are really very stark, that is a risk factor, and you need to be careful. So what kind of mitigation steps might you take? Well, alternative methods of reporting are important, and I believe Sarah will talk about that when she talks about investigations. But you want to make sure that the harasser isn't the one and only person to whom an employee reports, right? You want to have many means of reporting harassment. So that's important in order to make people who feel picked upon, give them an alternative means of reporting it. You might even consider a third-party hotline. There are organizations that offer these hotlines, 1-800 numbers people can call into. You might use one of those in addition to having internal compliance people available. And also make sure you're talking with everyone. So when you're talking with everyone, what am I talking about? You might do some periodic climate surveys of your employees and make sure you're getting feedback from people, from everybody in your workplace. How do they feel? How do they think things are going? Another risk factor the EEOC has found are workplaces that rely on customer service or client satisfaction. Well, I think most places do to some extent. But what they were talking about here specifically were people such as wait staff who have to interact with the clients. And the whole operation depends on how well they interact with the clients. And those people can be vulnerable to harassment because the boss knows you got to keep the clients happy, and the boss may tolerate some harassment of the workforce that interacts with the clients in order to keep the clients happy. So that is a situation that is a risk factor. That's a risk factor for harassment. What do you do? Well, you need to protect your workers. And employers, as Nate mentioned, they have a legal responsibility to protect their employees from third parties, from customers, from vendors, from visitors. And that goes back to the basic idea that you, as the employer, have the obligation to maintain a safe workplace. Safe workplace against anyone, right? You need to protect your workers. Contractual provisions. When you deal with subcontractors and vendors, have in there mention of sexual harassment. Make sure they understand your policy and that they abide by it. You might consider some surveillance of common areas where your staff have to interact. Again, these are just some ideas for how you might mitigate the risk. Another risk factor the EEOC found were workplaces where the work is monotonous or consists of low-intensity tasks. Monotonous or consists of low-intensity tasks. I think that means answering interrogatories. But at any rate, where that happens, where you have this kind of work, that is a risk factor. Employees get bored, and what's that old phrase? Idle hands are the devil's workplace. When people get bored, when they have time on their hands, they might get up to no good. So, expect professional behavior. As I said earlier, you want to stress civility and professionalism, not just the legal liability. Forbid horseplay and the practical jokes and roughhousing. That's for their own time. It's not for the workplace. Another risk factor, isolated work spaces. So employees that have to go out away from the eyes of managers and supervisors are ones at risk, such as the housekeeping staff at a hotel. They're at more risk. That's an employment situation where these workers are at more risk of being harassed. What can you do about it? Well, the city of Chicago enacted the hands-off, pants-on ordinance. And they are requiring all Chicago hotels to provide their housekeepers with panic buttons like that one in that picture. So that is one technological approach that maybe you should consider. Maybe there are others. A risk factor, a workplace culture that tolerates or encourages alcohol consumption. And this is a picture from the Mad Men TV series. And when you look at that picture, you might recognize several risk factors. You have a homogeneous workforce, you have young people, and they're drinking alcohol. And they're all male. So there you go. Be careful with the booze, which is, I don't know if we're having booze after this or not, but be careful with the booze. Implement your drug-free and your alcohol-free workplace. Make it clear in your policy that this applies whenever your employees are on company time, whenever they're doing company business, whether at the workplace, or outside. Another risk factor, decentralized workplaces, such as these old photo marts. I guess we don't have to worry about these little photo stands anymore, do we? But places like that, yogurt shops, push carts, etc. And it's similar to the workers who are within your facility but isolated. The same idea, people that are isolated or vulnerable. I've had a sexual harassment case involving a female security guard at a coal mine. She was out basically all alone in a shack at the edge of the property. There was no one there to watch over her. She's guarding the property, but who's guarding her? As it turned out, they didn't do a very good job. So don't be a stranger. Just as with the isolated employees, think of ways to keep connected, physically or technologically. So, in closing, the EEOC has said, risk is inevitable, right? Every one of you at your workplace are going to have some of these risk factors. It's just inevitable. And that's what the EEOC says. And the objective they have in identifying these risk factors, and the objective I have in bringing them to your attention today, is to consider how many of these are in your workplace and what are you doing about it? How are you taking steps proactively to stop harassment? So what are your next steps? Again, your leaders need to be committed to the civil, diverse, and inclusive workplace. And this isn't just a one-time announcement they make. This is something that is shown through the policies and procedures. It's shown through the training you give. And it's shown through how you investigate and how you enforce any complaints. Also, lastly, think about your risk factors and take steps to try to mitigate them. If you have any questions, I have a couple minutes, or if you want to wait till the end, we can talk at the end. We'll save about 5 to 10 minutes at the end. Going, gone. Okay, thank you very much for your attention.
My name's Mike Fry, and he just talked about the people who don't conform to norms. I'm the one in the office most likely not to conform to the norms. So just be prepared for that as we go through the presentation today. I want to, as a disclaimer to begin with, I want to say sexual harassment is an extremely serious issue in the workplace today, and it's extremely serious in our society. That being said, I have tried to interject a little bit of humor here and there into the presentation. It may fall completely flat. If it does, then I apologize in advance. It is not meant to belittle or to minimize the sexual harassment issues that confront this country and all of us in our workforces. So, with that being said, my job today is to talk about sexual harassment policies. Actually, it's policies that work, and sometimes they do and sometimes they don't. But why is a policy important? Well, the first reason it's important is because everybody in this room today wants to stop sexual harassment. And a good policy is a ground floor that you can build on for stopping that sexual harassment in your workforce. Now, My statistics may be a little different than Steve's statistics because they came from different surveys. But as you can see, sexual harassment is very serious and very rampant right now. This survey came from the tech industry out in California. And as you can see, 60% of women in tech reported unwanted sexual advances. 60% of those who reported that to their supervisors and to their HR departments were unsatisfied with how the thing was resolved or addressed. 25% of all the women in the survey had received lewd texts and emails. 1 in 3 were afraid for their personal safety. 80% of women in this survey had experienced sexual harassment in verbal form. 20% of men had been sexually harassed at work. 65% were harassed by their manager or their supervisor. 44% had unwanted touching and sexual advances. And 1 in 3 women ages 18 to 34 had been sexually harassed at work. So those statistics clearly show we have a lot of work to do. The consequences of not doing that work and not stopping sexual harassment are significant. For the victim, you have all of these problems. You're going to lose confidence, job performance drops, embarrassment, depression, feelings of fearfulness, self-doubt, victimization, all of those things that you don't want to happen to people in your workforce. On the flip side of that, the perpetrators, the people doing this, they have consequences as well. When it comes out, they're going to be facing public humiliation. They can be fired. They can be sued themselves because under the Human Rights Act, not only can the employer be sued, but the individual doing the harassment can be sued as well. If it gets back to the spouse, the family can break up. You can lose your friends. Depending on the severity of it, if it's a sexual assault, you could be looking at jail time. You could basically end your advancement in your career because of your sexual harassment you've conducted. And obviously, you're not going to be respected once that label has been placed on you. So there are serious and many consequences. So there are lots of social consequences. There are also legal consequences to having a policy. Legal consequence is that having a policy can protect you in sexual harassment suits from hostile work environment claims. There was a Supreme Court case a few years ago called Farragher, which probably most of you are familiar with, which essentially said that if you have a good policy in place and that it's being implemented and that the employer is taking reasonable care to prevent and correct harassment, then you can be protected from some employee-on-employee sexual harassment claims. Not supervisor claims, but employee upon employee. So at least it gives you some level of protection. Next, the third reason why a policy is important is because sexual harassment costs money. In 2015, the EEOC recovered from businesses in this country $164 million in fines that they had levied and on monies that they had collected on behalf of victims of sexual harassment. If the case goes to litigation in lawsuit, the average total cost of a claim is $125,000. That is the settlement cost and the cost of legal fees together. If it goes to trial in front of a jury, the median judgment on a sexual harassment suit in America is $200,000. And 25% of all judgments exceed $500,000. So you got those financial costs that are right out of your pocket money, but you've also got lost time to litigation matters because litigation is time consuming, it's disruptive, it's going to take your employees away from what they should be doing, which is doing their jobs because that's what they do best. It's also going to cost you in terms of goodwill. If it gets out into the community that you had a workplace that was rampant with sexual harassment and bad behavior, then the people in the community are going to look at you a different way. And obviously your employees are going to be affected as well. And an employee with low morale is not a productive employee. So your money tree that looks like that could very quickly end up looking like this as a result of sexual harassment. So creating a good policy. Before we go any farther, first I want to make clear that sexual harassment affects all genders and all positions. It's not just male on female. It can be female on male. It doesn't happen very often statistically, but it is and does happen. You do see quite a bit of male-to-male sexual harassment. We do see some female-to-female. I actually represented an employer in a female-on-female sexual harassment case just about a year ago. It's supervisor to employee. It can be employee to supervisor. It can be employee to employee. And it can also be participants to bystanders. Whenever I'm sexually harassing CR here and somebody at the other side of the table hears what's going on and is offended by it. So all those different ways that people can be the victims of sexual harassment. So, good policies. The Equal Employment Opportunity Commission has issued several guideline bulletin type things that said, essentially, these are the minimum requirements that we're looking for in terms of a good policy. So, I put them into what I call a top 10 list. And apologies to David Letterman. First, creating a good policy, you must clearly explain the prohibited conduct, and you must do it in language that all employees can understand. And why is that? Well, because all equal opportunity employers equally hire dumb and stupid people. And I'm not going to comment on whether or not that applies to my particular employer, but it does apply in a lot of places. So, you've probably seen a sexual harassment policy or in this form or some other form or fashion in numerous employee handbooks and handouts. My question is, would your least educated employee understand something like that? Because if they don't, then it's not really any point in even having the policy. So you must clearly explain, and the one way that the EEOC has said that you can do this is through providing specific examples of conduct that is being prohibited. Quid pro quo. You guys have already talked about with Nate a little bit about that, but famous quid pro quo here. Everybody remember that one? Quid pro quo Clarice. So let's hope that none of your employees are like Hannibal Lecter. But anyway, examples of quid pro quo. And again, you guys are educated enough and are familiar enough with this topic to know some of this stuff, but a supervisor coerces an employee into a sexual relationship and rewards the employee with a promotion or a raise. That would be an example of quid pro quo. Disciplinary action to an employee, but denial to another based upon rejected sexual advances from the supervisor. That would be one. A supervisor who disciplines or discharges an employee who ends a romantic relationship with the supervisor would be an example. And a supervisor who takes disciplinary action or denies an opportunity to an employee because he or she rejected sexual advances from the supervisor. All of those are examples of quid pro quo. The next type of harassment that you should put in your policy examples of would be a hostile work environment. And this is an actual letter from a case that I was involved in. If you can make out the sort of highlighted portion there, the employee who was filing this was trying to make a hostile work environment claim. But instead, what they called it was they felt like that in the workplace they were in a hot style environment. So to me, hot style is somewhere on a runway in Milan, but this guy apparently thought it was in his own workplace. But this is an example of why your policy has to be in language that people can understand. Because obviously this person who was making this complaint did not understand hostile work environment. Types of hostile work environment. Displaying pinup calendars or sexually charged pictures. Now, one of the guys in the office asked me, does this actually even happen anymore? And it does. I've seen situations where you have, particularly in industrial settings, tool rooms, locker rooms, those type of things, lunch rooms where a primarily male workforce still will do things like this. And a lot of times it's part of a frat boy mentality where people are just, they're joking, but it does happen. This is a real problem. Sexually based or offensive pictures on cell phones. That probably is where, if you're going to have a picture that's inappropriate for the workplace, that's going to be a problem for you, it's going to be on somebody's cell phone. It could be something like two employees who are engaged in a consensual relationship, who take pictures of each other, and then the relationship goes bad, and next thing you know, those pictures are being disseminated to all the other people in the workforce. It could be someone who just thinks it's funny to show people and get a reaction out of them from pictures. And as you know from your own dealings with the internet, and Rule 34, which basically it means that if there's, if someone can think about it, if there's porn about it, then that people will find it on their phones. Hostile work environment also includes repeated unwanted sexual advances and insistent requests for dates. As Nate talked about, just asking for a date or sending a letter or giving an employee a personal gift is not sexual harassment in itself. It has to go to that key word where it becomes unwelcome. And if it's not unwelcome or if it's not severe and pervasive, then it hasn't really crossed over the line yet. Sexually oriented remarks. That would be another type of hostile work environment where you have lots of jokes, teasing, catcalls, comments on people's appearance, workplace graffiti, and if you have an employee who's doing this, oh my, then you definitely have a problem, and that person needs to be addressed. Another way sexual harassment can pop up in the office for a hostile work environment is people talking about their own, their own sex life. People love to come and brag, particularly men. They love to talk about their frequency and their size and their prowess. Some people like to share their sexual fantasies, and other people like to just talk about what they and their spouse did last night. If that's going on, that can also create a hostile work environment. And if somebody is talking about their prowess, I will refer them to this Dane Cook quote. That would be usually what would happen to me. So, other hostile work environment: brushes, pats, hugs, pinches, grabs, kisses, strokes, massages, bites, and gropes. All of those, don't be doing it. Or if you or your employees. As I'm going to show my age here. Not going to do it. Wouldn't be prudent. Nonverbal harassment. Even the best of us at times. So you got Barack Obama there. Was he or was he not? I know that was an issue. You guys can make up your own mind whether he was. People flash in the workplace. That's nonverbal, but it's harassment. Nonverbal gestures. And this last picture there was actually one that caused a difference of opinion in our office. And so as Nate was talking about, changing social norms and being sensitive to all ends of the spectrum, there were certain people in the office who felt that was perfectly acceptable to put in a sexual harassment presentation. There were other people in the office who thought that was completely no way that should be in there. And so I left it in there strictly for the purpose of being able to tell you guys that. So again, it stretches an entire continuum of behavior. Hostile work environment normally will take more than one occasion, as Nate indicated, but even one occasion, if it is severe enough, will create a hostile work environment, and that would be considered generally in the cases of sexual assault or severe touching, or if a guy takes off his clothes and walks around in front of you, that's probably going to get to the level. Consensual relationships is an issue that comes up quite a bit for us, and again, it goes back to whether the conduct is welcome or unwelcome. Social invitations are generally acceptable. But again, voluntariness does not equal consent. Someone may go on a date with a supervisor, but they're not doing it because they're consenting to it. They're doing it because they feel like they have to, or they're going to face some sort of consequence in the workplace. And just a statistic on that, this is from Psychology Today, a survey from a couple years ago. 47% of workers in offices had been involved in an office romance. So this is something that's going to come up quite a lot. And when this becomes a real issue is when the relationship is over. Okay, the second thing on creating a good policy is dissemination. If you're not going to disseminate the policy, then it's not going to do you much good. Employees have to know about it, so you need to post it in conspicuous locations. You need to make sure it's in your employee handbook. It needs to be part of the orientation materials, and if you have a website, you should put the policy on your website. A good policy will also have a provision in it that's going to call for no retaliation. People are worried that whenever they make a complaint that they have been harassed, that they're going to have something bad happen to them later on down the road as a result of that. So even though the statute makes retaliation itself unlawful, people are still worried about that. If someone makes a report, if they end up filing a lawsuit, even if the lawsuit is won and they're not able to prove sexual harassment, they can still prove a separate claim for retaliation if you treated them or if someone treated them badly after making the report. So you need to keep that in mind. The most common reason for not reporting is because the victim not only thinks they won't be believed, but they think that they're going to be fired as a result of making the report. Item 4 in a good policy is confidentiality, and that's basically, people don't want their dirty laundry aired, and they don't want embarrassing things getting out to the other employees, so you need to include in your policy some sort of statement that assures them that they will not be, that it's going to be kept quiet to the extent that it can be kept quiet. You're never going to be able to keep it completely quiet. There's always going to be situations where it's going to get out, but you need to try to keep it as confidential as possible, and you need to be aware that you're probably going to run into employees who are going to say, I'm telling you this, but I don't want anyone to know about it. So if that happens, all you can do is tell them, I understand your concern. I will try to keep it as confidential as possible, but we have to investigate because we have to do something about it if you're being harassed. If not, we could be looking at significant legal liability down the road. A good policy will also describe the complaint process. So it needs to tell the employee exactly what's going to happen in response to your complaint, who's going to be carrying out the investigation, what the different steps are going to be. And as Steve indicated, you always have to have somebody outside the chain of command who they can go to in case the person in the chain of the command is the one doing the harassing. Your policy also should state that the investigation will be prompt, thorough, and impartial. People are concerned that they won't be treated fairly, and everybody wants to be treated fairly. One thing that comes up a lot of times in investigation is, should we take some sort of interim relief? Should we move this person here, move that person there to get them out of the situation? And the answer to that is yes. But in doing so, you have to be very careful that you don't put some additional burden on them. If you move them into a position where they're now having to do twice the work, then that's going to feel like retaliation to them. So you have to be very careful when you do that. Your policy should also say that if someone has harassed you, that we're going to take immediate and appropriate corrective action. And that corrective action can run the gamut. It can be reprimand, it can be suspension, it can be a lot of different things. It could be to give them the boot out the door. But again, that depends on the severity of the conduct and whether or not that conduct has taken place in the past. Number 8, you should emphasize a no tolerance policy. And that's because sexual harassment has many shades of gray. And I know it's spelled wrong. It should be EY. You know, I had a situation that I read about here not too long ago where there was a lady who had a calendar up in her cubicle, and it was a college cheerleading calendar. And the reason she had it hanging in her cubicle is because her granddaughter was one of the cheerleaders who was in the calendar. But the calendar also had, you know, all of the girls were in pretty skimpy outfits. So another female in the office saw that calendar and complained of sexual harassment. Said it was created a sexually charged workplace and it was demeaning. So, you know, as I said, it's shades of gray, because for that grandmother, that clearly wasn't sexually meant to sexually harass anyone. But for the person in the workplace who was sensitive to that, it was. And so it goes the gamut of reactions to things. So because of that, a no tolerance policy is generally the way we want to go. We want to cast a policy in black and white and essentially say, you know, keep your hands to yourself and you keep your comments to yourself, and, you know, we don't put up with this stuff in the workplace. And, you know, part of that is wanting to make sure that your employees feel uneasy about thinking about their coworkers in sexual terms. You know, we want the employees to have a certain level of concern that if I sexualize my coworker and I make comments or something, then I'm going to lose my job. Something bad's going to happen to me. So maybe I just shouldn't go down that road to begin with. The 9th thing in your policy has to be a provision that says you're going to train. And so, again, you want to train on the policy itself. You're going to have to train on the complaint procedure, types of conduct that constitute sexual harassment. And whether or not you train is one of the things that will be very important should a charge be filed against you and people come in to investigate. And number 10, sexual harassment is not just for work hours anymore. Used to be, all you had to worry about was what happened between 8 and 5 when they were in your office. Nowadays, with social media, with Twitter, with Facebook, Snapchat, go down the list. I don't know them all. I'm too old. But you're going to end up with complaints because people are being harassed even after they leave the workplace through those electronic means. And that kind of plays into the technology in the workforce issue, which as technology has moved into the workforce, things like smartphones, computers, all that kind of stuff, and particularly with the internet, you see a lot of inappropriate usage of it. As these statistics bear out, 10% of people have used instant messaging at work for sexual, romantic, or pornographic chat. 27% of organizations have been subject to sexual harassment claims arising from employee abuse of computer systems. 26% of all employers have terminated employees for email or internet misuse. And 70% of all pornographic traffic on the internet occurs during regular business hours, which was an amazing statistic when I saw that. The key question there for your employee is, if a message, picture, or web page is inappropriate to share with them face-to-face, it's equally inappropriate to send it to them via Snapchat. The lesson there is we live in the era of smartphones and stupid people. So, take that for what it's worth. To go back and hit the top 10 again in short form, you want to make sure you explain the conduct, disseminate your policy, make sure it says you're not going to retaliate, make sure it says you're going to keep everything confidential, describe the complaint process, describe the investigation, describe corrective action that will be taken, make sure that it says you do not tolerate sexual harassment in any form or fashion, it says you're going to train people on that, and have some sort of internet or social media policy as a component of it. And with that, I'll turn you over to Gary Matthews for employee training.
My name's Gary Matthews. I'm another attorney from Jenkins Spencer Maker. You all been standing or sitting here for a long time. If you all want to stand up, move around, shake your arms, do jumping jacks, I don't care. Make sure you're not getting sleepy, because this is kind of a sleepy topic, what I have. I'll be talking about training and what we do in the workforce. And you see, they're already asleep. You've got Jim and Pam, they're just hanging out there. Creed's in the back. Nobody was really paying attention while Michael's talking. That's kind of like what I'm afraid is going to happen in the next few minutes. Anyway, the first thing that you want your training to be is about culture, culture, culture. You want your employees to understand that their workplace is a place where they can feel safe, that they can feel that they can go to work and go home and not have to worry about whatever may come from someone else, sexually, bullying, whatever. What I'll be talking about doesn't really just apply to sexual harassment. It can go to bullying in the workplace. It can go to really any type of conduct. You can apply a lot of these thoughts to them. So what I'm going to give you is a little discussion about culture, why we kind of the three emerging concepts of training, and then a little checklist at the end that we can talk about. The goal of your training is to shape your culture in your business to prevent sexual harassment. You want your people, like Mike said, to feel uneasy about sexualizing their coworkers. And you can do that, one of the ways is through your training. And more importantly, you want to promote your civility and your respect in the workforce, in the workplace. If people feel respected where they work, if people feel that they can talk to each other in a nice, easy way, you're less likely to have these types of situations arise. A lot of training can be, when you're talking about the policy issues that Mike just discussed, a lot of those are narrow issues, but training can also be big picture ideas and broad swipes of the brush. There's an EEOC article, and Steve Snyder talked about it pretty extensively, but there were two kind of concepts that came out of that I found pretty important. And the first one was a workplace where employees are not civil to one another can be the forerunner to workplace harassment. The second one is a move to disrespect in the workplace often allows harassment to take place without consequence. So if you can change your culture, if you can make promote your culture to be one where people are comfortable with each other, but comfortable to where we want to be respectful to each other, then you're less likely to have these situations. I'm going to discuss three concepts of training. The first one is probably the oldest. It's legal liability type training. Some people call it compliance training. The next two are more recent concepts of training, civility training and bystander. Legal liability training became popular in the 80s and the 90s. And it became popular because there were some court decisions, Farragut and Ellerth, that talk about what an employer can do if they get a claim. And one of the things they talk about is that one of the defenses that they can raise is that they took reasonable action to prevent harassment in the workplace. And one of the things that we can look at now as to what would be reasonable is, did you train your employees not to do these things? Did you train your employees to be civil? Did you train your employees that quid pro quo is wrong? Did you train your employees that you can't retaliate against them if you don't get what you want, or if you sexualize them in the workplace, that this is wrong? All those things go to the things that can be trained, and it came out of those court decisions that this was a type of thing that should be done. This old type of training, it's going to usually have a lengthy discussion of the law, It's going to be definition-based, like you've already heard what quid pro quo is, what is retaliation. The new commentators, the new research suggests that why it's not effective, and it hasn't been effective, why we still have sexual harassment claims, is because it focuses on what shouldn't be done in the workplace, what you can't do, what you should not do. It doesn't focus on how we should act and what our expectations as employers should be with our employees, how we want them to work. And it also is going to give usually a hierarchy of information on how to make a complaint. You know, who do you go to? What's your policy? That sort of stuff. It's going to be black and white material. It's not going to be particularly interesting, and that's why I put Toby Flenderson up there. Toby was the HR director, or HR manager at Dunder Mifflin, and I always thought that this was the kind of training that he would give if he were doing what I'm doing right now. You know, Toby on the show The Office was a sensitive guy. He was respectful to everybody, but he was kind of black and white, and you know, he's got his bulletin board back there. And I always thought that he would tell you, this is what we do, and this is what we don't do, and be very black and white about it. Very book oriented about it. The newer types of training are different, and they are, like I've mentioned, geared toward creating an idea of respect in the workforce. These things were developed by people that were intending to prevent bullying or workplace conflicts. You know, you thought that if everybody was respectful, there wouldn't be bullying. Well, they've now applied those to sexual harassment issues. These are going to focus on expectations of how employees should act. We want you to be friendly with people. We want you to treat everyone the same. We want you to be friends and coworkers. We want everyone to be respectful. It's going to provide the employees with the expectations of their managers and give them ways to meet those expectations. It's going to be one component of a broader type of training. It's usually going to involve some type of interpersonal training. It may have given managers new techniques to deal with people and how to make their discussions with their employees be more civil. And I keep using that word, but that's what we want, that respect among employees and among coworkers. We're not telling, in the civility type training, we're not telling people what we don't want them to do. We want to tell them how we want them to act. We want to tell them that it is appropriate for us to discuss someone's inadequacies in the workplace, but it's not appropriate for us to use slang words or put people down. It's not appropriate to use something that you wouldn't talk to your mom about. That sort of thing is the way I think of it. You know, you want to be able to be very black and white about what your policies are and how your discussion should be, but you don't want to do it in a disrespectful way. One of the things that the researchers talk about, that this type of civility training can be better suited to employment and sexual harassment, is because you're not telling people what they shouldn't do. An audience where this training may be passed along to, people may not feel like they're singled out or being targeted. So historically, when do you get training? After something happens, after an event occurs. It may not be the next day, it may not be the next month, but sometime it's going to happen after an event. And if you're talking in positive terms, the people that may have been the perpetrator that may still be there, the person that may be the victim that hopefully is still working, may not be feel singled out or targeted by the discussion that comes about. And that is an important idea in civility training, because it makes it more respectful and furthers the goal of the employer to keep people working. I always thought Sheldon Cooper should have more civility training in his work. Sheldon, there was actually an episode where he was alleged to have sexually harassed an intern and the HR director later by just the crazy things that he says, the weird way he talks. And in that episode, his punishment was that he had to go through an online course of civility training, of sexual harassment training. He made his intern go through the course because he was too intellectually superior to deal with the situation. That was the tone of the episode. Sheldon wasn't respectful to his people, wasn't respectful to his coworkers. I think that he would have done much better to have that type of training if he had actually gone through with it. The last type of training I'm going to talk about is bystander training. And I think this is probably the newest form of training that's coming about. Stephen Snyder talked about it briefly. The EEOC has written some articles about it. The EEOC picked up on it from situations where it was intended to prevent sexual assault on college campuses and in high schools. I think you can consider it Good Samaritan training. It's geared toward third parties who observe harassment and giving them ways to help the situation. It's not going to work unless you've already created that culture, that morale, that you've got to be civil in the workplace. But I think it is a new tool that people could use in their companies. It's going to have 4 concepts. The first 2 deal with your culture and what your morale is. You're going to create awareness and recognition of problem conduct or behavior. What is good and what is bad? What can we do? What can't we do? You're going to motivate your people to take action when they see something that's inappropriate. Now, in the sexual assault context that Mike Fry talked about at the end of his presentation, I think this would work well. Where it doesn't work quite as well is in just communications and conversations where people are talking and there may be other people around. I think that the idea that third parties can step in is a great idea, and if you've created that culture in your workplace that things aren't appropriate, then this could be helpful to you. The next step, they're going to teach the bystanders how to intervene when it's appropriate, and tell them when situations give rise to a time to step in. And then they're finally going to give people the help or the resources to actually intervene and help. And there was a company called Green Dot. It's a training company that it developed these 3 Ds when it created its bystander training. And I think direct, distract, and delegate are the 3 things that they talk about. You want to be direct with the perpetrator as to what the harassment conduct was. You distract the perpetrator so you can get the victim away from that conduct. And then you delegate the person would then delegate the situation to someone that could really help, whether that's the HR department, whether that's upper level supervisor, however your company is stratified would determine that. But direct, distract, and delegate are its 3 concepts. Now, I put Pepe Le Pew and Penelope Pussycat up there because if Elmer Fudd or Bugs Bunny or Daffy Duck or anybody else, Foghorn Leghorn, any of them had really watched what was going on with them, bystander training could have helped. Pepe Le Pew was probably the most persistent person ever, and that's a lot of P's when I say it. But he was chasing her everywhere, putting his hands and paws and tail and whatever else on her in ways that were not appropriate, that should never have happened. And if any of the other Looney Tunes gang had been watching, they should have stopped this. And the direct, distract, and delegate may have helped. The other end of that spectrum is, I think this is bystander training gone wrong. That's Franklin J. Hart from 9 to 5. And Dorley and Judy and Violet probably went way too far with what they did in that movie. He was the supervisor. He was the person that they would have made those comments to. They would have addressed his bullying tactics, his theft of ideas, his sexual harassment. In normal situations, that's who you would probably go to first. But he was the guy doing it. So HR, another manager, another supervisor, other employees, those who, if they had known through training where to go, who they should have gone to, but this is what they did. They locked him up in his own house, and production went up, and they all got raises, and all was happy ending, but it was probably a really bad situation in the real world on a lot of levels. The last thing I'm going to give you is a checklist. I think if you take anything away from my ramblings, this is probably what you'd want to think about. The first thing you want to do is evaluate the kinds of training you're currently doing. And you want to use the situations that you've already seen in your workplace to tailor your training to what you're seeing. If you're not tailoring your training to what you have in your workplace and what you might have in your workplace, then you're probably not helping yourself or your employees. The next thing is you want to make training a priority. If it's not scheduled, if it's not regular, if it's not something that you dedicate yourself to as an employer, it's not going to work. So I would recommend that you would definitely do it with new employees, that you definitely do it on an annual basis, that you definitely have employees sign off on that they have received training. And then I think that training on random times intermittently in that annual cycle can be helpful. You know, whether depending on what type of employer you are, you might have a toolbox talk, or you might have a weekly safety meeting, or just a weekly project meeting. You know, throw one of those topics in. What's appropriate, what's civil, what's respectful, and what's not can be helpful. So make it a priority. I think you want to mix up the kind of training you're doing. There's a lot of ways to train people. You can have somebody standing at a podium with a clicker and talking for 2 hours. Whether that's helpful or not, I don't know. You can have videos. You can have interactive discussions. Role-playing was very popular in the late 90s for sexual harassment training. You know, I don't know if that'd be really acceptable or something we'd want to do today. But there's a lot of ways to train people. And I think if you're doing it the same way every time, then you're probably missing out, and your employees are probably zoned out like you all are right now. So I think you'd want your training to be more like that than that, again, asleep. But anytime you can be interactive with your training, where you can prompt discussion, where you can prompt questions, where you can prompt people and make them feel comfortable in discussing issues, you're better off. You're going to want to include all levels of your company. It's got to be from the highest person in management to the rank and file employee. And I think it's very important and makes your training more memorable and more strong if the rank and file employee can see those top people in management there, right there with them in the room, sitting, going through the same types of training that they are. Now, I think that management needs more training than the rank and file employee, but that basic training, everybody should get, and I think you should do it together, collectively. I think it makes it more memorable and more important to the lower level employees. The same line, you've got to get buy-in from everybody. Everybody's got to understand that it's a priority for the company to be respectful, to be civil, that sexual harassment isn't going to be appropriate in the workplace. And you've got to get an understanding from all levels of management, from all levels of the rank and file employee, that that's the emphasis that the company is going to have. Just like you've heard all day, you're going to want to discuss that company culture and what is acceptable, what is not acceptable. You've got to provide the information on your company policy. You've heard from Mike Fry what is the policy and what you've got to include in it, but you've got to train it. You've got to make people understand it, and you've got to make people hear it, know where they can find it if they have an issue, and be able to understand it. It can't be a bunch of legal jargon on a page. It's got to be something that a normal person can read and understand. If this happens to me, I need to go to this person, or I can go to that person. And you want to give them more than one avenue to deal with that. You're going to provide information on how to report a situation. I think something that gets left out a lot of times is you want to provide information about how the investigation is going to be completed. I think a lot of times people wouldn't report this situation or a safety issue or a bullying problem or any other problem because they don't know what's going to happen after they make the report. So you want to make sure that they know, if I tell this person that I've been harassed by this other person, what are they going to do to me? How am I going to be involved in this from then on? How's it going to stop? Are they going to come talk to me? They got to know all that. And knowing that will help people be willing to report a situation when it happens. And I think you also need to provide information on discipline. What is the range of discipline for certain conduct? It's everything from termination, dismissal to verbal reprimand or whatever it may be. People need to understand that there are consequences for their actions. And the last thing I think you need to do is evaluate your training again. After you've done it, you need to constantly go back and look at it again and say, what's happened since the last time? What's new in the world? How can I do this better? And if you do that, your training programs they're going to change over time. They're not going to be static, and people are going to learn from them and hopefully change your culture. So unless anybody has any questions, I'll have a seat.
Hi, I'm Sarah Walling. My practice at Jenkins Fenstermaker focuses on labor and employment and insurance coverage. Fortunately for you, I'm not here to talk about insurance today. The last speaker is always in the unenviable position of holding you up from asking the questions about the things you really want to know, and also from the food and drinks that I saw them setting up out in the hallway. So I will keep that in mind as I go through my presentation. What I'm going to do is just bring us full circle. Nate started off talking about state law. I'm going to cover some federal law and just sort of wrap us up today. So let's assume that your company has done all of the things that we've talked about today. You have a good anti-harassment policy, you've distributed the policy and provided training to your employees, and you've attempted to reduce the risk of harassment in your workplace. So what happens if you have a Harvey Weinstein type who thinks that the rules don't apply to him or her, and he or she violates company policy, and your company ends up as a defendant in a lawsuit? Is the company liable? If you can show three things, the answer might be no. First, if the company has not taken an adverse action such as demoting or firing an employee who's made a complaint. Second, if you can show that the company has taken reasonable care to prevent harassment and promptly take action when a claim is made. And three, that the employee unreasonably failed to use the reporting procedures provided by the company. So this defense comes from these two U.S. Supreme Court cases that are listed up here. Farragher v. City of Boca Raton and Burlington Industries v. Ellerth, they were decided on the same day in 1998. They came out of similar facts, but they had very different outcomes. So let's start with the Farragher case. The plaintiff, Beth Ann Farragher, was a college student who worked as a part-time lifeguard during school and in the summers for the City of Boca Raton. She worked there from 1985 to 1990. During her time as a lifeguard, she had 3 supervisors, Bill Terry, David Silverman, and Robert Gordon. Terry had the authority to hire, fire, discipline, and basically supervise all the aspects of the lifeguards' jobs. Silverman and Gordon made their daily assignments and supervised their work. So Terry and Silverman harassed the female lifeguards pretty much throughout Ms. Farragher's time that she worked there. Terry was the worst. He told her he would never promote a woman to the rank of lieutenant. He also gave her the option of dating him or cleaning the toilets for a year. He would simulate sex with female lifeguards. He asked during interviews if women would be willing to have sex with their male counterparts. Silverman wasn't any better. He would pantomime oral sex. He would make disparaging comments about the female lifeguards' bodies. He would tell them that he wanted to have sex with them. Gordon didn't really engage in that. Ms. Farragher saw him as a friend and sort of a trusted mentor, so she told him what was going on, but he never reported it to anybody higher up the chain, and she never asked him to. So Farragher resigned. She sued the city and Terry and Silverman. She won at the trial court level, which held the city liable for Terry and Silverman's behavior. The city appealed, and the federal appellate court reversed. So Farragher took the case up to the U.S. Supreme Court, and it reinstated the district court's judgment because it believed that the city had no hope of showing that it took reasonable care to prevent harassment. So what did the city do wrong? Well, it did have a policy. It adopted it in '86, it readopted it in 1990, and it distributed it to some of its employees. So what's the problem? The lifeguards never got a copy of it. Based on this, the Supreme Court held that Farragher had no reasonable way to make a complaint. She didn't even know the policy existed. She had never received a copy. So in the Ellerth case, this is still Farragher, sorry. In the Ellerth case, the plaintiff, Kimberly Ellerth, worked as a salesperson for Burlington Industries. She was harassed by a guy named Ted Slowick, who wasn't her immediate supervisor. He was referred to as a mid-level manager, so he was a step or two above where Ms. Farragher was. Slowick was just as bad as the guys in the Farragher case. In the summer of '93, he invited Ellerth to a hotel lounge. They were on a business trip together. He made comments about her body, complimented her breasts, and told her that he could make her life at Burlington very hard or very easy. In March of 1994, Ellerth had a promotion interview with Slowick where he told her that she wasn't loose enough and he rubbed her knee. And in May of 1994, Ellerth had to call Slowick to request approval of a design. She had a customer who wanted to insert their logo into a fabric, and she needed Slowick to give the okay for that. Slowick told her that he didn't have time to talk with her unless she was going to tell him what she was wearing. So she ended the call, and because she still needed the approval, she called him back a couple of days later, and he said, "You know, Kim, your life here would be a lot easier if you would just start wearing your skirts shorter." So Ellerth resigned, and she filed suit against Slowick and against the company. The initial rulings in the Ellerth case were actually the reverse of Farragher. Burlington won summary judgment in the district court. The Court of Appeals reversed it. And in this case, the Supreme Court held that Burlington was still subject to liability, possibly, but it remanded the case to give Burlington an opportunity to show that it had taken reasonable care to prevent the harassment. So what was different in the Ellerth case? Well, Burlington had a harassment policy, but it also had internal complaint procedures. Ellerth acknowledged that she knew about the policy, and she also acknowledged that she had failed to take advantage of the complaint procedures. So the holdings in these two cases have resulted in what's called the Farragher-Ellerth defense. And it's exactly what I said at the beginning. An employer has to show reasonable care to prevent and correct promptly any sexually harassing behavior, and it also has to show that the employee unreasonably failed to take advantage of any preventative or corrective opportunities provided or to avoid harm otherwise. So what does this mean? Well, the goal of everyone in this room, I think, is to encourage your employees to report harassment, to make it as easy and comfortable as you can for them, because that'll protect not only your employees, but it'll also protect your business as well. So you can do this in a number of ways, some of which have already been touched on today, but just a recap. You can have a policy, you can distribute it, and you can stick to it. Take your complaints seriously. Investigate them promptly. Investigate all of them. Discipline the offenders consistently, regardless of their rank within your company. Show your employees that you stand by your policies and that you will not hesitate to enforce them. Provide multiple ways to report harassment. A couple of the guys earlier talked about the percentage of harassed employees who have been the target of a supervisor or someone with authority over them. So what you want to do is make sure that your employees are not forced to make their complaints to the very person that's harassing them. So we all come from a variety of different size companies, different types of organizations. So depending on the size and setup of your business, it might mean that you have your employees report to their supervisor, but also give them the opportunity to report to a compliance officer or an HR department if you have it. You might also contract with a third-party company to set up an anonymous hotline to report concerns. Or for smaller organizations or for nonprofits, you might designate a board member or outside counsel as someone who is appropriate to make a complaint to. The bottom line is that you want your employees to feel safe and secure and to give them an opportunity to report to the person that they feel most comfortable with. You also want to use a variety of investigators to look into a complaint after you receive it. The individual designated to investigate might change depending on the severity of the behavior that's raised, depending on the harasser's position within the company. You may have concerns that they would be able to exert some sort of influence over the investigation. So by having a variety of investigators to choose from, you do everything you can to ensure that, that complaints are handled in a fair and non-biased way. And finally, lead by example. Know your employees. Know what goes on at your business. Be someone that they trust with their concerns. And at all times, foster a workplace culture of respect and equality. That's one that'll keep your employees secure and also protect your business as best you can.